Mr. Chairman, we are live.
Thank you. All right. Well, welcome to the Judiciary Committee meeting for March 17th, St. Patrick's Day. Today, I hope everyone wore their green. Oh, Mike might be in trouble.
It's colorblind. It's a green shirt, sort of. It's grayish green.
All right. Well, we are working both in the virtual world and the in-person world. Our in-person world is vacant this morning, but hopefully there's some folks out there in the virtual world that tune into the bills that we're going to hear today. And so, Clarissa, do you want to call the roll, please?
Absolutely, Mr. Chairman. Representative Crago,
Here.
Representative Larson,
Excused.
Representative Oakley.
Here.
Representative Provenza.
Here.
Vice Chair Washit,
Oh, excused.
Representative Williams,
Excused.
Representative Yin,
Here.
Representative Swanitzer,
Here.
Chairman Olson.
Here.
Mr. Chairman, you have 6 present and 3 excused.
All right. So today we're going to hear 3 bills in the following order: Senate File 110, Small Claims Procedures, then Senate File 23, Public Meetings, Executive Sessions for Security Plans, and then House Bill 247, Law Enforcement Hiring Practices. So let's begin with Senate File 110, Small Claims Procedures. I'm pulling the bill up. This bill is sponsored by Senator Chairman Nethercott, and I am a co-sponsor, so I will walk you through the bill. Okay, so what this bill does, it's a good little procedure bill, and it deals with small claims court. So all this bill does is amend the statute to allow actions for small claims procedures to be brought in the county where the cause of action or some part of the cause of action arose. And the genesis behind that, and I think Senator Nethercott circulated an email to the committee, so the committee is probably fully aware of the genesis behind this bill, but I do want to just speak about it for a moment so that our public can understand what we're doing here. Basically, in small claims court, and we're talking about, actually, I don't even know the dollar amount off the top of my head, $6,000. So on claims under $6,000. So those are very small claims. And the way the statutes are designed currently, if you have an action that arises, say, in Teton County, that's where your claim arises, but you're on the other side of the state. Maybe you're in Laramie County and you want to bring an action in Laramie County against the individual in Teton County. You have to serve the individual in the county where the claim arose or where you file. And so this bill gets rid of that idea and lets you serve anywhere really in the state of Wyoming, which would be consistent with our other claims, well, not other claims courts, excuse me, our other courts of law in Wyoming. So really, this bill, one, brings consistency across courts in terms of service of process. But two, I think really what it's designed to do is create a more equitable system where folks have a better chance of getting into court to have their small claims adjudicated. And I think that's pretty much it. Questions, committee, or comments on the bill? No? All right. Clarissa, do we have anybody in the virtual world with their little hand raised would like to comment on this bill?
Mr. Chairman, I do not see anyone who has their hand raised at this moment.
The House Judiciary Committee goes from a Friday session, the last time we were in session hearing a bill on the regulation of marijuana with so many people that we couldn't get all their testimony in within 4 hours, to a small claims Senate File 110 procedures bill. And that's just what the Judiciary Committee does. All right, we are on Senate File 110. Seeing no public comment, I'll close public comment. Committee, what is your pleasure?
Move the bill.
Moved by Representative Craigo, seconded by Representative Yin. Discussion on the bill. Amendments on the bill, amendments to page 1. Amendments to page 2. Amendments to page 3. This is an engrossed bill. Do we know what the change was?
Mr. Chairman,
Representative Craigo.
so the change was made on the floor and it extended the days on page 3 from 3 to 12 to 12 to 20. So it gave the court a longer time to hold the hearing.
Okay. Sounds like a good amendment.
It is a good amendment because I can tell you in practice, it often gets continued because of schedules. It just doesn't often, it's not able to happen in 3 to 12 days. So actually, I think it's a good amendment.
The courts are already doing it by practice anyway.
Yes, sir.
We're just gonna make it a little easier, maybe so they don't have to issue that continuance, go through that process, sign it, serve it, et cetera. Okay, very good. No amendments on page 3, no amendments to the bill. Clarissa, will you call the roll on Senate File 110, small claims procedures?
Mr. Chairman, this is a roll call vote for Senate File 110, small claims procedures. Representative Craigo,
Aye.
Representative Larson,
Representative Larson left a absentee voting form for Senate File 110. He votes aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Vice Chair Washit,
Vice Chairman Washit left an absentee voting form for Senate File 110. He votes aye.
Representative Williams,
Excused.
Representative Yin,
Aye.
Representative Zwanitzer,
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes, 1 excused.
Okay. So the next bill is going to be Senate File 23. Senator Cost is actually going to introduce this bill for us, and he's across the hall. I've messaged him, so we should see him any minute. So we'll just pause for just a moment while we wait for Senator Cost. Senator Cost, I was just getting ready to execute my subpoena power and send our good trooper over to escort you, but you made it. All right, Senator, welcome to the House Judiciary Committee. We are on Senate File 23, Public Meetings, Executive Sessions for Security Plans. I understand this to be a joint Judiciary Interim Committee bill, and I understand you're going to walk us through it.
Thank you, Mr. Chairman, and I was given the privilege of walking you through this. So
We were working on this summer as a joint, as you know, for those that were in the joint committee, and it was determined to carry this one forward. It passed, and so I'm bringing it. Senate File 23, Public Meetings, Executive Session for Security Plans, sponsored by the Judiciary Interim Committee. A little background on it. Originally, a year ago, it was a bill that I had presented, and it failed to make it through both houses. It made it through the Senate, but it didn't make it through the committee that it was assigned to in the representatives. That's just the way things go sometimes. At that time, there was an amendment created to the bill by the Press Association to make it a more amenable bill to them. And so that's what is shown in the bill that we currently have. If you look on page 1 at line 7, section 1, it talks about what's been added, 16.4.405A, by creating a new paragraph 12, or XII if you prefer, and C is amended to read. So if you go down to the executive session, line 10, and on down to 12, a governing body of an agency may hold executive session not open to the public, and then it goes through to describe the different situations which were left out. Added on page 2, line 1, was the 12th amendment or section, which is to consider, discuss, and conduct safety and security planning that, if disclosed, would pose a threat to the safety of life or property. And on down on C, it was, instead of through 11, it was changed to through 12 of this section. Basically, that's the entire bill. It was just simply to add executive session for security purposes. And it's important to remember that, first of all, somebody might say, well, isn't there one in there already that applies to security? There is an executive session for security, but it's of national security. And this is not talking about national security. What this is talking about is the security in schools and other entities when they start talking about firewalls and the entrance areas and how they control those for safety of students and others. Predominantly, I'm looking at it more from a school standpoint for the need to make sure that those things which could be put in the hands of the wrong person to be determined to be creating a threat to the kids or creating a threat to a school or a building is rather important. And so this opened that up so that they could go to that particular situation in an executive session. The important thing to remember is what the paper had put in, which was it would pose a threat to the safety of life or property. And I think that was the critical issue that the press was having a hard time with. Other than that, they endorsed it. And with that, I will attempt to answer any questions any of you may have.
Committee, Senator Cost, I think you just touched on what would be my question, which was, I'm looking back at the 2020 bill and I'm comparing it to the bill that we have now. Your 2020 bill said to consider and conduct safety and security planning for the protection of life and property. This new bill doesn't just require that the conversation be about safety and security planning for protection of life and property, but that it, like, I think what you said was that it actually has to pose a threat to the safety of life or property. It looks like the other addition would be the word discuss, as opposed to just consider and conduct, but now can discuss without taking any action on the matter.
Mr. Chairman, and of course, an executive session, and I'm sure you guys are probably well aware of it, but having been in the hospital as the president of the hospital board at our local hospital, as well as 2 other boards that I've been on. Executive session is obviously a discussion, but never an action. Action can only take place when you're outside of executive session. And so when we're talking about, like on a hospital credentialing of doctors or whatever, when we're looking at their personnel file to make that decision, that's all confidential. But as soon as you go out of executive session, then you can report that you approve the credentialing of the particular person. But as far as getting into the details, it's left to the executive session. That would be the same in something like this, where there'd be a situation where possibly getting through the security system or looking at escape routes or whatever they're working with that is they feel is posing a possible threat, then it would be necessary to consider that in executive session, but then any decisions must take place outside of executive session.
And Senator Cost, help me understand. So I'm looking at 16-4-405, existing statute, and there's a list that the governing body of an agency may hold an executive session not open to the public for. And the first of the list says, and it gives us a list of who, but it includes attorney general, county attorney, district attorney, city attorney, sheriff, chief of police in this meeting, and says on matters posing a threat to the security of public or private property or a threat to the public's right of access. So it seems that this exception that we're creating is in part, at least the property aspect of it is covered by the statute. The difference would be these individuals in the list don't have to be in the meeting, I suppose, which is maybe why what you're talking to us about the school scenario, school board scenario.
Mr. Chairman, that's exactly it. Unless they have deemed that the material they're going to talk about is ahead of a time that they can get a policeman there, or they could get their lawyer, which obviously when you have the lawyer at a meeting is going to cost. They're not able to discuss that. And so rather than so-called breaking the rules or the law, this allows that freedom to be able to discuss that as a board without having to try to make the lawyer present or a police chief or somebody that would represent the law enforcement. Yes, sir.
And this applies to a governing body of an agency being defined, I'm assuming somewhere else in statute. And agency does not include the University of Wyoming and the community colleges. Are those the ones not on the list?
Mr. Chairman, I've never had that question asked before, and I can't honestly answer it intelligently. So I'd have to defer that to somebody that might know more than I on that one.
Representative Crago?
Mr. Chairman, I think it depends on which part of the APA we're talking about. We're talking about Chapter 4, I think it does include them, but if we're talking about other aspects, contested cases, et cetera, I don't think it does. So it depends on, if I remember correctly, I'd have to go pull the statute, but I think it depends on which part of the agency is defined differently within the APA, depending on which chapters we're talking about.
Okay, I was just, logically, it would make sense to me because the title of 16 is city, county, state, and local powers, uniform municipal fiscal procedures, public records, documents, and meetings, and then executive sessions. So I just thought maybe logically we had excluded them from 4, but maybe you're saying it's the opposite.
It's defined in 402 definitions.
In 402? 16
Or
402? And who does it include? Representative Yin, please tell us.
Mr. Chairman, agency means any authority, bureau, board, commission, committee, or sub-agency of the state, a county, a municipality, or other political subdivision, which is created by or pursuant to the Wyoming Constitution, statute, or ordinance other than the state legislature the Judiciary, and the Consensus Revenue Estimating Group, and the Investment Funds Committee.
Aha,
So basically everyone except for the exceptions.
except for us.
Yeah.
And the judiciary, which is probably important. I mean, could be a question we receive. It doesn't sound like it was a question that the Senate had. Could be a question we receive on the floor to know that we're at least accepted from this. But I'm sure we have our own process somewhere else in statute because I've been in many executive sessions on security issues. So anyway, okay. Any other questions for Senator Cost? No. All right. This is a good little bill too. All right, Senator Cost, we appreciate you. We'll, you can stick around if you want for a couple more minutes. We'll see if we have any public comment.
Thank you, Mr. Chairman, and I will hold for a little bit. No problem.
Excellent. Thank you. Clarissa, do we have public comment?
Mr. Chairman, we do. Brian Farmer, Devin Brewbreaker, and Bob McLaurin have all raised their hand.
All right, let's go ahead and let Mr. Farmer in. And then we'll go to Bob, and then I missed the name, but we'll go to the last person on your list there. You just want to go in that order. Mr. Farmer, welcome.
Thank you, Mr. Chairman. Brian Farmer with Wyoming School Boards Association, speaking on behalf of the bill. As Senator Cost pointed out, this really is a useful tool for school district governance. You noted the exception that depends on who's in the room. And it would be fairly rare, say for the chief of police, to be in an executive session for a school district. And let me give you an example. We have a district right now who's very interested in issues related to cybersecurity. They need to talk about some things that they as a district are doing in order to protect the district, the students against those threats that potentially come online. Things that would be best discussed outside of their regular public meeting. And so in order to do that, again, it depends on who's present in the room. So if their attorney is there and their attorney is giving them legal advice, then it can be an executive session. But this bill would really just kind of help to deal with those different instances where there is a threat to the security, safety of the public, people or property. Of course, the one that would be the biggest concern would be that instance of mass violence, a time where there is a threat to the safety of the school and a need to be sure that the governing body have the opportunity to be in executive session to talk about and make plans for those instances of mass violence, where you certainly don't want the wrongdoer to potentially hear about those precautions that the governing body would take. Now, again, as you've mentioned, any decision does need to be made in the public session. And that's something that I think we're good with. I think that that's something we're used to. And so just ask you for your favorable consideration of this bill. Certainly something that would help school districts and I imagine other governing bodies as well. Thank you, Mr. Chairman.
Questions for Mr. Farmer? Mr. Farmer, would there be I understand, so I really appreciate your explanation of the exception that's already in law that depends on who's in the room issue. And I definitely appreciate that issue. My question would just be, would there really be a scenario where on the other side, where the school board would hold an executive session without their attorney present? I can't imagine that would be the case, but maybe.
Mr. Chairman, I think that's unique to every situation and every jurisdiction across our state. There are many of our smaller communities where the attorney is not a local individual. As a matter of fact, there are a couple of firms that represent a number of districts. And so without special arrangement, they're not present with those individuals. As a matter of fact, as these laws develop and pursuant to school district policies, some of them don't allow for the virtual participation right now in those executive sessions. There are questions about how private or how secure the executive session is when you have an individual participating virtually. And so there are some that have made that determination that it is not appropriate for them to do so. So let's say your attorney is in Powell and your school district is in Lusk. It may not be possible unless that person travels to be present with you. And so a lot of times what they may be considering, again, let's say that they're talking about, say, cybersecurity. They may be talking about known threats and things that the district is doing in order to address those threats. Perhaps the insurance company has a program for cybersecurity. Maybe there was a ransomware incident and they were talking about here's what has happened, and they're advising the governing body as to how they are dealing with that instance. So it's going to be unique to every single situation. The instances I bring up are just conversations that I know have happened across Wyoming of different places that have had issues that they've needed to consider. And if possible, I think they do like to have their attorney present, but that's not always practical for that to happen.
Thank you, Mr. Farmer. Very helpful. I guess I wasn't thinking of rural communities and that issue, but now that makes perfect sense to me. Other questions for Mr. Farmer? All right.
Thank you, Mr. Chairman.
All right. Bob, you're on deck.
Mr. Chairman, I'm Bob McLaurin. I'm with WHAM. We stand in support of the bill for many of the reasons articulated previously. So I'll be happy to answer any questions, but our members strongly support the bill.
Thank you, Bob. Questions for the Wyoming Association of Municipalities? Committee? No? All right. Thanks, Bob.
Mr. Chairman, we have Devin Brubaker next.
Ah, yes. Let's bring in Devin.
Mr. Chairman, this is Devin Brubaker with the Wyoming Airports Coalition. I'm having some issues with my camera, so I apologize this morning. Can you all hear me?
We can hear you. Yep.
Okay, sorry about the camera, but just briefly, the Wyoming Airports Coalition stands in favor of this legislation. Oftentimes, it's not remembered or considered that airports are guardians of sensitive security information pertaining to air travel through the Department of Homeland Security. This addition to the statute would allow us to consider and communicate that sensitive security information in executive session with our governing bodies. And much like the school districts, the existing statute that does allow for discussions like this, it requires the attorneys or a chief of police, but airport board meetings largely will not have those members in attendance. And attorneys do not always attend the board meetings unless there's a specific legal issue at hand. So it's our preference that the bill be considered favorably, and happy to answer any questions.
Committee questions? All right, Devin, thank you.
Thank you.
Anyone else in the virtual world that wishes to testify on this little Senate file?
Mr. Chairman, I do not see anyone else with their hand raised.
All right. How about in the room? We're on Senate File 23, public meetings, executive sessions for security plans
Mr.
Jeremiah.
Chairman, members of the committee, I'm Jeremiah Reman here on behalf of the County Commissioners Association. We do support this. There are situations where county commissioners working with other county staff do find them in sensitive security situations. I was sharing with the Senate Judiciary Committee. There you have a couple of former commissioners, one of them who happened to be from Park County. And when the Hells Angels came through, that certainly would be a sensitive situation where this might be an appropriate time to invoke executive session. So, Mr. Chairman, we do stand in support.
Questions for the County Commissioners Association? See you wearing your green today, Jeremiah. So is the trooper, but I don't think that counts. All right. Any additional public comment? No public comment, closing public comment. Committee, what is your pleasure?
Move the bill.
Moved by Representative Yin, seconded by Representative Craigo. Discussion on the bill. Representative Craigo? Amendments on the bill. Amendments, page 1. Amendments to page 2. All right. No amendments to the bill. Seeing no discussion on the bill. Clarissa, will you call the roll on this Senate File 23?
Mr. Chairman, this is a roll call vote for Senate File 23, public meetings, executive sessions for security plans. Representative Craigo,
Aye.
Representative Larson,
Representative Larson left an absentee voting form for Senate File 23. He votes aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Vice Chair Washit,
Vice Chair Washit left an absentee voting form for Senate File 23, and he votes aye.
Representative Williams,
Excused.
Representative Yin,
Aye.
Representative Zwanitzer,
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes, 1 excused.
All right. Looks like we're on a roll today. Should have scheduled 5 more bills. Thank you, Senator Cost. Enjoy your meeting. All right. We'll now move to House Bill 247. And we have Representative Provenza, who is the chief sponsor of this bill, and will walk us through it. To the hot seat.
Good morning, Mr. Chairman, committee. It's a, quiet morning. I bring to you today House Bill 247, law enforcement hiring practices. The sponsors on this bill are myself, Representative Washit, and not listed on this version, but Senator Landon is also a co-sponsor if this would pass the House. The purpose of this bill is threefold and comes from some direct experiences that my community has had issues with that I'll kind of walk you through. But ultimately at the core of this bill is that finding and employing the right people in law enforcement is the foundation for creating an organization that effectively serves the community. The main purposes of this bill is to protect the sanctity of law enforcement by prohibiting officers with a demonstrated history of serious misconduct from obtaining certification and employment within the state of Wyoming as peace officers. This is important for a couple of reasons, specifically because officers with a history of misconduct have a tendency to propagate further misconduct and have lengthy records of such. One study in 2019 demonstrated that officers with records of misconduct which transitioned and moved around the department within the police force consistently increased the likelihood that those around them would be accused of bad behavior. The other portion of this is that we find that oftentimes we have a small percentage of officers, anywhere from 2 to 5%, that account for as much as 50% of complaints within their agency. So they tend to continue on this path, but we don't have a way of kind of keeping record of that information or being able to track who those people are. The second purpose of this bill is that it directs agencies to submit their serious misconduct information to the Peace Officer Standards and Training Office for record keeping. Currently, agencies are responsible for performing their own background checks on officers prior to hiring. So they have to determine if someone is fit to serve. And then this is something that can be expensive, particularly for small agencies, that doesn't really incentivize thorough investigations. We also have seen that different agencies across the state have various standards for record keeping. In my county, I can give you a specific example from our previous sheriff's policy manual, which has on page 26, after 1 year, the employee may submit a written request to the sheriff for consideration of removal of disciplinary actions regarding written reprimands. If the request is approved, the disciplinary record will be removed from the employee's file and destroyed by shredding. So we certainly don't have a good way of ensuring that all of our agencies across the state are holding the records that would be necessary to keep someone who's maybe engaged in serious misconduct from moving on to a different department. And this provides uniformity in handling of serious misconduct cases, which, as someone who quite literally has developed a scientific scale on public perceptions of police legitimacy, I will tell you that the consistency and transparency and accountability is incredibly important. Another issue that I've come across in talking with Post, so the Peace Officer Standard and Training Office, which you received an email from their director, Chris Walsh, yesterday, stated that this bill would help in ensuring that agencies share these misconduct records, and that in conversations that I've had with Mr. Walsh, there has been an issue in trying to obtain those records. Sometimes it requires a court subpoena, and courts aren't always clear in terms of if Post is seen as the supervisor of those records. So in Wyoming statute, in public records, we see that Wyoming statute denies the right of inspection of public employee personnel files, except to the officials who supervise the work of the individual in question, and further denies the right to examine records or information compiled solely for purposes of investigating violations of and enforcing internal personnel rules or personnel policies, the disclosure of which would constitute a clear, unwarranted invasion of personal privacy. Oftentimes we see that agencies want to comply. They want to work with Post. They will submit that there has been serious misconduct that has happened. Other times we don't see that. Agencies might be invested in protecting an officer. These are people we work with, after all. These are people that, you know, we think do good things most of the time. And oftentimes that might be true. But when we have someone that is harming the public's perception of law enforcement as a whole, then we need to consider, is that person good for law enforcement? So this bill I've brought with Post, and he's, unfortunately, Director Walsh is not here today, cannot testify. He has a hearing, but has shared with me that this would kind of help in ensuring that he can get the records that he needs when he's doing his investigations. Post is the entity that determines whether an officer should be certified, what training they need, and if they should be decertified or have their certification revoked. So while Post has established rules for peace officers and coroners, they do not necessarily have statutory authority to obtain or maintain misconduct records. So at that, I will walk you through the bill. On page 1, we find that just the title, we're adding a section. So we're in this, it says on page 1, line 11, adding new subsections M through P is amended to read. I would say that section L is not in the statutes in 9-1-704. So I would, that was probably a typo. L and O should be those letters. And the next section we see, or in the same section, so this is saying, notwithstanding any provision of law to the contrary, no person shall be eligible for appointment as a peace officer when the person was previously employed as a peace officer and the person, and it goes through the different requirements that currently exist. I will tell you, we have not changed these laws or standards primarily since the 90s when we created post. The last amendment to these statutes was in 2007, and that just changed some wording around for correctional officers, I believe. In lines 11 through M, this is demonstrating that the commission shall revoke the certificate of any peace officer who is dismissed, resigns, or retires under the circumstances specified in subsection M of this section, prior to the denial or prior to the revocation of the certificate, and goes on. So essentially, if an officer is found to who's been dismissed for serious misconduct, which we define later in this bill, they are no longer eligible to maintain their certification. And additionally, if you leave, because oftentimes what we see is if you're being investigated for serious misconduct and you resign your position, then there's not a finding in that, but you would be subject to this rule under that circumstance. And additionally, lines 20 through 23, and then lines 1 through 4 on page 2 and 3, any employing agency who investigates a peace officer and finds that the peace officer has engaged shall submit a full report along with a copy of all supporting files. This is to ensure that there is record keeping of serious misconduct cases. This is not all misconduct. This is not incidences of someone had a bad day at work and made a mistake. This is serious misconduct, which we define in what would be subsection P or O if we amend the language, lines 8 through 14. This is improper or illegal actions taken by a peace officer in connection with the officer's official duties. This might be a miscarriage of justice, or it would result in a miscarriage of justice, including but not limited to conviction of a crime, unlawful acts of discrimination, fabrication of evidence, excessive use of force, acceptance of a bribe, or fraud. This is a definition that other states, it was modeled after, but it's not something that we have put a lot of reins on because we want to ensure that we allow some wiggle room there. And then this act shall apply only to acts on or after the effective date. So making sure that we're not just going to automatically revoke certification of peace officers who might fall under this previously. And then other acts of this are effective immediately upon completion. So here on out, certification is contingent on whether you have engaged in serious misconduct or not. And with that, I will stand for questions.
You may sit.
Okay, I will sit for questions. Thank you, Mr. Chairman.
Committee, questions for Representative Provenza? Representative Craigo.
Representative Provenza, I had one question down at the bottom of page 2. And this might just be a sort of a clarification or something maybe we could clean up, but this involves the investigation piece. So if we look at line 22 and it says has engaged in that conduct. So my concern is member of the public makes a complaint and alleges somebody has engaged in serious misconduct. And then the PD or the SO does their investigation and finds that the person probably did something wrong, the officer, but it was not serious misconduct. So they did engage in the conduct that was alleged, but it does not rise to the level of serious misconduct. The way I read this, we would still have to report that to post. And the way I understood your testimony was really what we're trying to capture is the serious misconduct. And so I was wondering if, we could change conduct where it says engaged in that conduct, if we could change the language to engaged in serious misconduct. Would that line up with the purpose of the bill in your mind?
What page and line are you on?
Page 2, and it's lines 20 through 23,
Okay.
essentially, but 22. Yeah. Does my question make sense to you?
Yeah, thank you, Mr. Chairman, and thank you, Representative Craigo. It certainly sounds like it would align with the purpose of the bill, the intent of the bill. The intent of the bill is not to force all agencies to submit all misconduct to post. I don't know what the burden would be on agencies if we did that. So it's not the scope of this. The scope is to ensure that. So if I'm not sure, if in the lines on lines 22 and finds that the peace officer has engaged in that conduct, I think is trying to refer to that serious misconduct, but I can understand if the clarification feels like it needs to be made, I would kind of defer to the committee on that.
So Representative Craigo, you're talking about line 22 where it says that conduct, which is your fear is that conduct is not referring to serious misconduct on line 21?
That's correct. Well, my fear is that it's referring to the actual allegation of misconduct, which may not end up being serious misconduct. It may be misconduct. It may be a bad act or a mistake, but it may not rise to the level of serious misconduct. So if the investigation shows that the person did what the allegations say they did, then we would have to report that. The way that, as I read the statute, we'd have to report that rather than the PD finding, yes, they did it, but it was not misconduct. And so we're not going to, or serious misconduct, excuse me. And so we're not going to report it to post.
I see. So maybe something like any employing agency who investigates a peace officer for serious misconduct and which results in a finding of serious misconduct shall submit a full report along with a copy.
Mr. Chairman, I think it's even easier than that. I think you just strike the two words that conduct and insert serious misconduct. And we can talk about that more if you'd like when we get to the amendment portion, but that was my only question and my only concern in the bill. Thank you, Mr. Chairman.
Further questions for Representative Provenza? Representative Oakley.
Thank you, Mr. Chair. I guess what I'd like to discuss, Representative Provenza, is okay, so if we look at page 2, line 8, M2, it says resigned or retired from the person's position while under investigation for serious misconduct. Now, of course, I understand the idea being you can't trying to stop somebody from resign from having from the consequences. But my question to you is, then how would this not affect or possibly affect a due process right for somebody? Because there is, when it comes to a post certification with no findings at all, which is what this would seem to implement. So, and then if you look, and then in combination with that, if you look at P1, so page 3, line 8, the definition of serious misconduct also, I think you said wiggle room, but the definition could be as simple as improper action. So an officer or somebody with certification could resign their position. Somebody has said they've taken some improper action, and technically that would fit under this bill. Do you agree with that? And do you see that there could be due process issues with that?
Thank you, Mr. Chairman, Representative Oakley. To the concern of leaving a position while under investigation for serious misconduct. I mean, I guess I would look at that as the same as a guilty plea, given that this is employment and not the court of law. They can stay and wait for a finding if they believe it's in their favor. And of course, the officer, knows what they did or did not do. But if they believe that, the issue being that we might see that officers are just leaving while they're under investigation so they can go find other employment, knowing that if they stay and wait for the misconduct to be founded, then they won't be able to obtain employment afterwards. So if we remove that portion of it, then we open up a big loophole for folks who want to maybe challenge the structure of the language here. In terms of the improper, I certainly can understand there being maybe some feelings of squeamishness of this improperness, but the issue is that sometimes you might not have an officer who's engaging in illegal misconduct in which they're breaking the law. They might just be demonstrating this very serious pattern of behavior that when it comes to light is then seen as serious misconduct. So some of this is going to fall under discretion again of officers, and if this is challenged to a court, then up to the court to determine that definition if it's challenged.
And
or
Representative
post, I guess.
Provenza, so maybe Representative Oakley, you can help me with this, but as I read the definition of serious misconduct, it seems to me that the point is to elevate it above something that is merely improper or something that is merely illegal, because there's actually a conjunction that requires it to be either improper or illegal and taken by the police officer in connection with the officer's official duties, that could result in a miscarriage of justice. So it must be improper and must result in a miscarriage and could result in a miscarriage of justice, or it must be illegal and could result in a miscarriage of justice. So the whole idea is to elevate that above a simple misconduct action. Is that
Mr. Chairman, that is correct.
Is that right? But so I don't know that much about post. So would a improper or if an officer engaged in an illegal action, would that be reported already?
Mr. Chairman, that's a good question. My understanding in talking with Post is that oftentimes they have not been informed. In a case in my county, I have informed Post of officers who have been arrested that they were not otherwise. Post did not, to my understanding, was not aware of that arrest. So not all agencies should be. I believe that there might be a rule under Post's rule, but I don't think that it's a uniform policy of agency heads.
I feel like as a lawyer, I wouldn't even get 24 hours before the Bar Association knew that I had engaged in illegal activity, and I'd have the Bar Council on the phone with me. I think that would be common amongst my certification. Did you have a question? Okay, Vice Chairman Washit.
Thank you, Mr. Chairman. I apologize for being late. I had to be in another committee this morning. My name's on this bill, so I'm obviously in support of it because I like what it's trying to accomplish. But in your research on this bill, did you hear anything about agencies that when during their background process before they hire folks, who the agency itself is misled by the current employing agency, maybe out of state, and therefore the agency in Wyoming has no idea, no information about this. And if that's the case, if they were to hire somebody and then after the fact become aware, how would this bill apply?
Representative Provenza.
Thank you, Mr. Chairman and Representative Washit. There certainly are cases in which agencies have not had everything they've needed. I know most of my conversation has been with post, so it's not in terms of hiring, it's kind of on that back end, right? There is a Yale law review that talks about what we call a wandering officer. So officers that leave an agency have engaged in misconduct, and that record doesn't necessarily follow them, or the agency that's hiring can't get access to it. What in my introduction, I discussed law enforcement agencies that have a hard time kind of obtaining all the resources that they need to do a thorough background investigation, right? So that what this bill would do is allow for those serious misconduct records to be under post and make that process a little easier. Then it's a phone call to post. It's not a checking with each employer that this person reported that they worked for.
Representative Oakley.
Yeah, so I'd like to return to this. I've certainly am still uncomfortable with the definition of serious misconduct. We just had a discussion that the intent of defining it was to elevate it, things like that. But my question is, does this definition do that? Because I will still go back to, well, there's two things. One, there is a list, but it says including but not limited to, ... So it still goes back to that it could be as broad as serious misconduct means improper action. And so first of all, I think that's, I think that we have not necessarily caught elevating what serious misconduct is supposed to do with this definition. And then, so taking that back to several times you've said when they have a demonstrated history, when they have a history of misconduct. But again, I don't see that. The history language in here, I see it as broad as an improper action. And what I'm concerned about is, could that mean, and then I want to go back to the resigning. So could we be at the place that any person in the community makes an allegation against an officer of an improper action, and maybe they're just moving and they resign? Would they be in danger of losing their post certification under this? And my question again, just being, is this a little too broad? Because even though you said, there's you don't want the loophole of them quitting, and I certainly understand it, but quitting is not the equivalent of a guilty plea, and nor should it be. That would give anybody in the community the ability to complain about an officer, and it could take away the ability for their livelihood. The combination of the two is concerning to me. Like I say, the definition, the relatively broad definition of serious misconduct in just an improper action being serious misconduct. And again, in combination with somebody resigning or retiring, means that they, while they're under any investigation, could make them ineligible to maintain their certification. So is there any further discussion from you regarding that, Representative Provenza. I want to get there and support this, but I have some reservations about due process rights for officers.
Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman. Thank you, Representative Oakley. I think what's missing here is that Post is an established law enforcement oversight agency that's already doing investigations, that already understands what serious misconduct looks like. I don't foresee that Post would be, maybe lack for a better term, trigger happy in trying to remove certifications for something like a simple civilian complaint of officer conduct without some sort of evidence to suggest that. So this doesn't mean that automatically if an officer resigns after being accused of any misconduct or any improper behavior, that they're going to be removed. It just means that if they have engaged in serious misconduct and on what their agency submits to Post as serious misconduct, they house that. I know that the investigation process by Post is thorough, it's thoughtful, it takes months, and it's not taken lightly. So I guess I struggle to see that Post would use this to decertify officers when they really shouldn't be.
So back to the I don't fully understand Post, obviously investigation process, but to this issue, if it sounds to me like the issue is actually that when an officer resigns or retires, Post has the authority to just drop the investigation. Wouldn't it? And if that's not true, and they can't drop the investigation, then they're going to have to have a finding. And the finding of serious misconduct seems to be the linchpin itself. And if it is true that Post can drop an investigation when an officer has been accused of serious misconduct and just resigns or retires, wouldn't it, I mean, what would be the problem with saying Post must complete an investigation when there is an allegation of serious misconduct, and a resignation or retirement of the officer does not cease the investigation? It seems to me like that would solve the problem.
Thank you, Mr. Chairman. Yeah, the process for Post is not that. So there would be probably an internal affairs investigation, or the agency would look into it itself and then submit that to Post.
Oh yeah, sorry. So I misspoke. So not Post, but the agency itself. It sounds like the agency doesn't have to complete an investigation if somebody retires. And that's the real issue.
Mr. Chairman, I believe that is correct. I don't know how agencies handle that in terms of what their internal processes are. I would imagine that Post, if they have an open investigation that they are conducting on an officer, what I've seen at their hearings before is that officers will they will essentially agree with the finding of Post, and they'll just volunteer their certification up, and not, then the investigation doesn't have to be as thorough, but they will come to a resolution with Post, whether it be that they submit back their certification, revoke it, or they suspend it.
And maybe Representative Oakley, what we need is, it sounds like we need to hear from our police chiefs association, from Post. And maybe if we take some testimony on, and we may have some online as well, maybe that will help with that conversation. Because all I have, which is unfortunate at this point, all I have is an email from the executive director of Post. And the executive director of Post says, discuss the bill with the authors. Post is willing and able to meet the standards proposed in HB 247, period. So I'm not saying it's not what you're discussing definitional wise isn't an issue, but my email from Post seems to indicate that they don't have an issue with it, but that's not the local agencies, and that's who we need to hear from.
Yes, Mr. Chairman. So I would, my concern, again, depending on it, is for a due process right for an individual officer. Looking at M and 2, the wording is no person shall be eligible for appointment as a peace officer if they resigned or retired while under investigation. It seems to me it's a bright line rule that if somebody, and I understand the intent behind it, I do. But we still have to have a discussion. Does that affect somebody's due process rights? That would mean that they could not be certified by post if they were under investigation and there's no findings. That by definition would mean there's no findings of misconduct. And we don't get to write law where that we, without findings, assume it's a guilty plea, if you will. That is what the due process issue is. And I'm not sure what we were talking about challenged by a court. I don't know if you want to, I don't understand how that would play in here. Maybe there's some tweaking of the words. Either I'd either be for completely getting rid of that they were resigned or retired with no findings and can't be certified, because I do think that's a due process issue, or maybe some permissive language rather than this is no person shall be eligible if they resigned while they were under investigation. So I do think we have a potential due process issue.
Yeah, and I'm tracking with you, Representative Oakley. I just think we need to hear from the police association and officers on that issue. I mean, I don't disagree with you, but to your point, the legislature defines due process. That's what we do when we write law. So I'm not saying that we should in this scenario. I'm just pushing back gently, letting you know that the legislature could codify an entire new due process that is new to the world, and the court would use it as it may, and whether it's constitutional or not would be another question. But I mean, due process is defined by a legislative body.
And with all due respect, due process is a constitutional right. We don't get to take away due process for somebody's employment certification.
No, I'm not saying take away due process. I'm saying we get to define what due process is in that scenario. The Constitution affords every individual due process. Courts interpret what that means. Legislatures across the country also say what that means. In my opinion, the legislative body is the one who writes that law, not the courts. That's all I'm saying. Representative Provenza.
Thank you, Mr. Chairman. And Representative Oakley, this might help you. That the due process, I guess, of this is in lines 15 through 18 on page 2. So you find that prior to the revocation of the certificate of any peace officer under this subsection, the peace officer shall be afforded prior written notice with an opportunity to respond and may appeal the revocation in accordance with the Wyoming Administrative Procedure Act. And that is currently what Post uses as their due process. Thank you, Mr. Chairman.
The APA.
I think, yeah.
To my point, codification of procedure. Okay, let's take some public testimony. Clarissa, in the virtual world, because I'm not seeing Mr. Odekoven, who I would really love to hear from. Does he happen to be in the virtual world?
Mr. Chairman, I do not see Mr. Odekoven on Zoom.
Okay. We have Terry. He's gone. Do we have anyone in the virtual world with their hand raised?
Mr. Chairman, we have Ms. Chambers from the Attorney General's office.
Okay, let's bring in Ms. Chambers, Division of Victim Services.
Good morning, Chairman. Kara Chambers with the Attorney General's office in this capacity as the liaison for the legislature for the agency, which does encompass Post. I wanted to try to address a couple of concerns that I've heard raised. The Post Commission, since we have a couple attorneys on the committee, analogous to the state bar, all right? Officers are licensed through the post commission to be peace officers in our state. So any action on their certification would be similar to an action against an attorney's license. There is a property interest attached, and there are processes in place through the Wyoming Administrative Procedures Act. Again, the standard would be arbitrary and capricious for any agency action. I wanted to try to address some concerns raised by Representative Oakley. I'd like to point to page 2, the concerning language, but I'd like to point to line 1 and 2, that notwithstanding any provision of the law to the contrary, we believe that provides the appropriate sideboard for any employment action, any other action against one's license, that there is a process and procedure in place to make sure that these actions aren't taken without proper notice and proper weight being given. I believe the resigned or retired question, again, very narrow, really referring only to officers who take this option while under investigation. This would be akin to an attorney who is facing disciplinary action and says, well, I'll just give up my license. I'm not going to practice law. Of course, if one is not engaged in that activity, relinquishes their license, post would then have a limited scope. If they give up their license and they don't work in that capacity, post as the licensing entity would have little jurisdiction. But I want to be clear that wouldn't forestop any potential criminal action that may have arisen. So I just want to be clear that we're talking about 2 different activities. And then I also want to point out the sideboards that are present on page 3 in the definition of serious misconduct. So means improper action, but that could result in a miscarriage of justice, including but not limited to conviction of a crime, unlawful acts of discrimination, et cetera, et cetera. So it's not just a mere improper act. You violated our code of conduct, et cetera. There are other provisions for that elsewhere, but I just worry that we were getting a little too far afield. This could be far too arbitrary and capricious, and that there weren't the appropriate sideboards available within the statute as written. And with that, I'd really just stand for any questions regarding post and the agency. I agree. I would like to hear from the Wyoming Sheriffs and Chiefs as well. But again, this statute is under the Peace Officer Standards and Training Commission. So this really reflects only with the licensure of those officers. But I believe it would be helpful to hear from the Sheriffs and Chiefs as far as how they feel about this and interpret agency action.
Vice Chairman Washit.
Ms. Chambers, thank you for being here this morning. Thank you, Mr. Chairman, for recognizing me. With this interpretation of lines 8 through 14 on serious misconduct, improper actions, but then it's, as your testimony indicated, limited to improper conduct that results in a miscarriage of justice, including conviction of a crime, unlawful discrimination, fabrication of evidence, excessive force, acceptance of a bribe, fraud, et cetera. So I think that language works, that improper is not just the officer didn't wear his hat, those types of low-level things, but rather improper that affects those qualifiers below. And I think I read that paragraph the same way you do.
Ms. Chambers, is that, just to be clear, is that what when you said that lines 8 through 14 on page 3 have the appropriate sideboards using the magical legislative language? Is that what you're referring to as the sideboard?
Chairman Olson, Representative Washington, yes. And I was giggling because I wasn't sure if there was a question. Yes. So it would have to be an improper act while under the color of that officer's badge. So while the ops taken by a peace officer in connection with the officer's official duties. So again, reining it in, and then, which could result in, et cetera, et cetera. So really trying to allay the concerns that this could be, as Representative Washut described, de minimis activity. This is a definition borrowed from other, my understanding from Director Walsh, from other states. They are comfortable with this. This is not, yes, it has the appropriate sideboards.
And Ms. Chambers, the other sideboard you referenced is on top of page 2, the notwithstanding, which I suppose is common legislative lingo. And in your opinion, we don't need to make it any more clear what the procedure is that applies. It's very, in your opinion, I mean, would it be unusual for us to just specify that because it's the APA that applies? Why not just say the APA shall apply to all of these proceedings, or we say that elsewhere, I suppose?
Chairman, that is explained elsewhere. Almost all, actually all, not almost all licensing entities in our state, unless they've exclusively exempted themselves from the APA, is how it works with our licensing board. So yes, it is stated elsewhere. I don't believe it's necessary, but I'd leave that to your discretion, sir.
Okay. Yeah, I'm just trying to help Representative Oakley get there with us on it. That's all. What could make it more palatable? Representative Oakley.
Thank you, Mr. Chair. So, good morning, Ms. Chambers. Thank you for being here. So what would you say to, excuse me. So I do understand what you're saying. So the notwithstanding any provision of law to the contrary, or referring to the APA, how do you respond to that? It says no persons shall be eligible for appointment as a peace officer if they, going down to 2, resigned or retired while under investigation. That do you hold it open that there would be a way where an officer was under investigation, which could be brought by any member of the community, quite possibly in law enforcement scenarios, for whatever reason, they quit or retire, let's just say they quit under that, that there would be no findings of misconduct, and that this says that they then shall not be eligible for appointment as a peace officer without any findings?
Ms. Chambers.
Chairman Wilson, Representative. So again, the statute that you're looking at amending here is the Peace Officer Standards and Training Commission. So this whole section of the law is talking about how we license officers. So the under investigation would be by post. So the interpretation would be that if an officer resigned while under investigation by post, yes, it feeds into itself as far as, again, I'm trying to make that analogy to the state bar. If I were under investigation for misconduct or what have you by the state bar, and I said, well, I'm not going to practice law anymore, you can see where that sort of renders some issues related to my license moot. However, if I then come back and say, well, actually, I'd like to re-up my license, I want to take this job, that this would open the state bar to looking into the fact that I sort of avoided a finding by relinquishing my license and escaping the authority of the licensing commission. So that is what this is trying to get at. Again, I think that notwithstanding under any other provision of the law, obviously, if I were an officer who decided to retire or resign because I felt that I was being wrongly accused of something, I have other avenues to pursue that. There are employment law avenues that I can pursue, et cetera. But our agency is personally not concerned with this language. I understand what you're saying, but I do think there are appropriate limits and other avenues. Again, this section of the law only relating to the officer's license, if you will.
Thank you.
Committee, further questions for Ms. Chambers? Yes, Vice Chairman Washit.
Thank you, Mr. Chairman. Ms. Chambers, so I'm envisioning a situation where an agency did due diligence in their background investigation, didn't find anything problematic. Perhaps it was actually not revealed by the previous employing agency in another state. The officer gets hired, comes to work in Wyoming, and maybe there's no misconduct in Wyoming, but then it comes to light that we have this prior circumstance in another state. How would that be dealt with by post?
Ms. Chambers?
Chairman Olson, Representative. Okay, so this statute's only reflecting to state law, so you're correct. There would be that circumstance. I believe that other states have similar language. It really would be incumbent upon the agency that's intending to hire to ask particular questions. There are no sure things, I suppose. Should the agency that previously employed this officer not release information, or if, for example, they resigned in that state, gave up their P certification in that state, and then moved to our state. But this statute is our understanding of an attempt to try to limit that within the state. I would think, and this is purely opinion, I suppose, that, and this would maybe more properly be addressed by Wyoming sheriffs and chiefs who actually do the hiring. Again, our agency, aside from DCI, who does hire officers, we of course would look at a background and look for any red flags. And I guess I would just say that, beyond questioning an officer about circumstances that led them to leave their prior agency, you're correct. This really only covers agencies within the state of Wyoming. But my understanding is other states have similar language.
Further questions for Ms. Chambers? Thank you. Clarissa, do we have any other hands in the virtual world?
Mr. Chairman, I do not see anyone else with their hand raised.
All right. How about in the room? Nope. Not your bill. All right. Representative Provenza, I think that's it for you, although I don't believe you're wearing green today. So it must be a Representative Yin and Representative Provenza. Is this a party issue? Ah, okay. Solved. All right. Thank you.
Thank you, Mr. Chairman, and please don't pinch me.
Do you have any closing comments on this bill? Not related to St. Patrick's Day.
Sure, I'll make a closing statement.
Sure.
This bill is meant to protect the sanctity of good law enforcement. This bill is not meant to attack law enforcement. In my community, we have seen what the impact is of law enforcement who shouldn't maybe be certified because they have engaged in serious misconduct in other states and other towns and have worked there. In my community, it has cost someone their life. So I ask you to consider protecting law enforcement and people in our communities by moving this bill forward. Thank you.
All right, committee, seeing no further public testimony in the virtual world or the in-person world, I'll close public testimony. What is your pleasure on the bill?
Move the bill.
Moved by Representative Yin, seconded by Vice Chairman Washit. Discussion on the bill or amendments on the bill. Let's do amendments on the bill first. You have amendment? Representative Crago? Let me guess, page 2?
They're all on page 2, but I got several of them, Mr. Chairman.
Okay,
We'll start with the easy one first, which is on line 22. My amendment would strike the words that conduct and replace them with the words serious misconduct.
Okay.
And we may want to vote on that one separate from my.
Yeah, let's take them all. Let's just take them all one by one. Moved by Representative Craigo, seconded by Representative Yin. Discussion on the amendment. I think we basically discussed this amendment. Keep forgetting Representative Zwanzer's out there, so if I don't recognize you and you want to speak, make sure you just yell at me, Representative Zwanzer. All right, question on the motion. All those in favor of the motion signify by raising your hand. All those opposed, that motion carries. Clarissa, I'm assuming you got that one?
I did, Mr. Chairman.
All right. Representative Craigo?
So my second amendment is a little more complicated and it tries to address Representative Oakley's concerns, at the same time keeping the intent of the bill where it needs to be. Because I think, we're talking about,
What page are you on?
sorry, we're on
Line
page
are you
2. I haven't got that
Would you
far
like to
yet.
make the motion and then discuss it?
Yes, sorry.
Okay.
It might have helped if I explained it first, but sorry.
Well, that might help, but unfortunately.
Yes, I
Those guys who
apologize.
created the rules. and
Rules, I
process
understand.
Didn't let us do that.
I apologize, Mr. Chairman.
It's all right.
So my amendment would be this, line 7.
Okay.
Insert subsection little I.
Okay.
And insert the words voluntarily relinquishes his certificate while under investigation for serious misconduct. Period.
And then renumber.
And then renumber number 2 below as number 3, and then add the following language to the language that's already there. So it would read resigned or retired from the person's position while under investigation for serious misconduct, and the employing agency ultimately finds that the peace officer has engaged in serious misconduct. Period.
Okay. Second. By Representative Oakley. Now we can discuss it.
Thank you.
Go ahead.
Sorry. So here's what I'm thinking, and I'll explain why. Talking about giving up one's employment and giving up one's license are two different things, right? And Ms. Chambers was talking about the bar, okay, and taking your license. Well, in that circumstance, the licensing agency is actually doing the investigation. Here, we're not talking about the licensing agency doing the investigation. We're actually talking about your local sheriff's office. So this would be similar to my law office investigating me rather than the bar investigating me. And so we're mixing two different concepts there. I understand people who are under investigation by the bar often just relinquish their license and say, I'm going to take a 5-year suspension, or I'm going to take a 2-year suspension, or whatever it is, which I think my amendment in subpart 2 would address that. So if you just say, if you're under investigation and you voluntarily relinquish your certificate, or I'm gonna call it a license, whatever it is with post, that would cover what Representative Prevens is trying to prevent. People just walking away and saying, hey, have my license, but I'm gonna wait 2 years and come back, right? That prevents that bad act, what I'm gonna call a bad act. Part 3 then protects let's say our local sheriff deputy has been, let's say he was already planning on moving. Like he's been planning to move to a different city, a different state for 6 months. And 3 days before he quits his job, somebody comes in and reports him for misconduct. And let's assume for purposes of this discussion, it's not a valid complaint. It doesn't end up being serious misconduct. He then says, I'm moving, because he can't stay. He's had plans to move. He can't follow through with the investigations because he lives in California now. That would protect that guy. If the SO goes through, or the PD goes through, whatever agency he works for, goes through the investigation and finds ultimately that it is serious misconduct, then that would get reported. And he would be ineligible to be a peace officer in Wyoming in the future. But if they go through and find out that there was no serious misconduct, then he's protected. He could someday move back to Wyoming and be a peace officer here.
Vice Chairman Washer.
Thank you, Mr. Chairman. I speak in support of the amendment. I think it does clarify things a little bit. But I can say as a practical matter, I wish Captain Pritchard hadn't stepped out. He probably would have been able to tell us a little bit about how the highway patrol does internal affairs things. But I remember in my day that if you had a non-criminal misconduct case and an employee resigned, sometimes that case wasn't completed because you no longer had an employment action. It was kind of moot. And so nothing would go to post because the internal investigation was never completed.
Yeah, and I'm at least tracking with the second part of the amendment that qualifies the language under Romanet 2, which was my concern on at least what I thought was getting to the heart of the issue. But to your point, Vice Chairman Washut, I guess there's no real obligation. There may not be an obligation, at least, for the agency to continue an investigation if there's not a criminal misconduct. And I'm not sure, I guess I don't know what, other than closing the loophole, what would be the benefit of continuing the investigation? Thinking back to the bar example again, I feel like it's a little bit different because it's the certification scenario, right? So if I was under investigation by the bar and I just said, you know what, I'm going to close my law office, that wouldn't close the investigation on me because I still have a license. We continue. The problem is that I guess I'm a private lawyer. So if I were a public lawyer, if I were working for the county attorney's office and I had an allegation against me and it resulted in both an internal investigation and a potential bar investigation, and then I resigned, the bar investigation would most likely continue on my license while the county would say, well, he's not our employee anymore, so he's not our concern if it wasn't a criminal misconduct. And maybe I guess that's closer to the scenario. And I guess maybe that's my disconnect in understanding the different parties here. And Post may not have, maybe that's the reporting part of this bill, because Post wouldn't open an investigation unless it knew about it. As long as it receives it, the question is whether Post must continue investigating once the officers resigned from the agency. To me, again, I go back, that was one of my questions to Representative Provenza. I don't see why you don't just require Post. If Post, or maybe they were already required, I don't know. If Post knows about a serious misconduct, regardless of whether the individual remains employed or not during the investigation, it seems to me like the fix would be that Post has to continue the investigation. Representative Provenza?
Thank you, Mr. Chairman. I want to try and clarify, I guess, how the decertification process works, and maybe Representative Washut has some more information as well, but these aren't things that come to fruition because of civilian complaints. To my understanding, there's one officer under investigation because of a civilian complaint, and it hadn't really been done before. It's the agency head that submits that. So there's discretion in the agency head saying, well, you know, they messed up, whatever. I don't want to deal with it anymore. I don't want to put this person up for decertification, even though they did engage in serious misconduct. With the amendment, I mean, the voluntarily relinquishes misconduct. Those are probably the folks we're not worried about. The people we're worried about are the people who are really going to just dig their teeth in and say, okay, well, I want to continue working in law enforcement. I'm not going to relinquish. I'm going to leave and then try and continue working. And so maybe Representative Craigo can clarify, because I wrote down the wording for what you said for Romanet 2. I think I might have missed what would now be Romanet 3, what you clarified in that portion of the amendment.
Mr. Chairman, Representative Provenza. So just at the end of the language you already had in the bill, So after the word misconduct on line 9, I added the language, or the amendment would add the language, and the employing agency ultimately finds that the peace officer has engaged in serious misconduct.
Representative Oakley.
Thank you, Mr. Chair. And I think Representative Crago made that needs reiterated here. A really good point of understanding and keeping it separate, that about the local agency, the local police department, or the sheriff's office. Because you said these aren't civilian complaints, but that's exactly what happens. They might even be voluminous as far as complaints made to the PD or the SO. So this has, if they resign or retire while under investigation, then that investigation largely happens, or what we're talking about is being investigated at the local level. So with that, again, keeping these kind of, the internal investigation largely happens at the local level with these things. And anyway, and because of that, I think it's a good amendment.
Representative Crago.
Mr. Chairman, thank you. Here's my belief, is that if there is actual serious misconduct, the local law enforcement agency is going to finish the investigation and they are going to make that finding. All this does is protect the person who, in the rare circumstance, who does happen to be innocent and not, did not actually engage in any serious misconduct. And so if it is rises to the level as described in the bill, they will finish that investigation. They will make that report to post. I know in our county we will, and I will tell you, in our county we get public complaints and we investigate them all the time in our local sheriff's office and our local PD. I mean, it happens, I won't say on a weekly basis, but it just, people get mad and they file complaints and everyone gets its due course. And so it is I will say, we do spend time on it. It's not an every once in a while kind of deal. So, and most of them end up being, not rising to this kind of level. Most of them are just angry citizens, and sometimes every once in a while there is some validity to those complaints and those get dealt with. But I just was thinking that this would allow the person who we're talking, the one person, the person the innocent person that we are trying to protect, the guy who had already planned on moving, and literally 3 days before he decides to, or he's loading the U-Haul on his third to last day of work, he gets a complaint. I mean, he has already retired, he's under investigation, and there's no qualifier there, I guess. That's my point, is we just need a qualifier that there's some level of guilt there on that person, because that guy might be, or gal might be totally innocent and they'd already planned on retiring. And I think that's what Representative Oakley was worried about too. I think that's what we're trying to cover. I don't know if it does. I mean, I'm also willing to talk about it and fix it on the floor. I think it's doable. I mean, I don't think it takes away from the intent of the bill. And if there's some better language, we can come up with it. I think there's a way we can do that addresses everybody's concerns. I really do. Thank you, Mr. Chairman.
Representative Oakley.
Thank you, Mr. Chair, and to Representative Crago. I do think that's because you said a qualifier, but what it is a finding. And I think that's, so I'm good with it as far as that, because then it takes away the due process issue that we've hit on here, whether it's narrow or not, which is they don't have a licensure, possible suspension with literally no finding and possibly no act of, no serious misconduct or possibly no misconduct. So I think adding that there's a finding there certainly addresses my concerns. So thank you, Mr. Chair.
Question.
Yeah, I think I think it does what you want it to do, Representative Craigo, and I support it for that reason, which is keep the innocent actor from being caught in a statute that may be too rigid. I think it definitely does that. I don't think the amendment furthers the intent of the loophole that Representative Prevens is attempting to close. I don't think the bill itself really closes that loophole. Again, I think the statute has to mandate that the agency complete the certificate or complete the investigation. I appreciate what you're saying, Representative Craigo, but if men were angels, we would need no laws. And I think in Wyoming, we usually get things right. And I do believe that most of our, if not all of our local agencies would complete the investigation because it is serious, because we're talking about serious misconduct, and they would do it without the requirement. I appreciate that, and I have all the respect for those agencies in the world to do that. I think the intent of the bill is to catch that instance where that doesn't happen, the scenario where it's the good old boy who's received a complaint, and then he and his commanding officer or the police chief realize, okay, all we got to do is have you accept your retirement or resign, and we can just close this one out. And I think, I'm not saying that happens, and I'm not saying it happens every day. I'm not even saying that it happens more than once in a decade in Wyoming, but I think that's the intent of the bill, is to find that scenario where, the agency isn't doing what we would hope it would do without a law to require it to do. I don't think that this bill closes that loophole. I think that loophole will absolutely occur, especially with the amendment, because if it's not a criminal action, as Representative Washut pointed out, the agency has the authority to drop it. I think that's something I'll be interested in looking at, I guess, on the floor, is whether the agency is already required, and what scenarios we might require them to complete the investigation. I would assume everyone will be on board with that, meaning the stakeholders. If what you say is true, Representative Craigo, that the agency would just continue the investigation because it's the right thing to do, then I don't think they would oppose a mandate that they have to complete any serious misconduct allegation through investigation. So I think the amendment's fine, but I think more work might get to the heart of the bill of what Representative Prevens is trying to address. Representative Craigo?
Mr. Chairman, I agree. That's an easy amendment. We just add another provision to the bill. I mean, in a separate paragraph that I think we can easily fix that either here today or between now and when we get it to the floor. We can draft an amendment that all of us support. I'm in full support of that amendment. Makes perfect sense to me.
Okay. Representative Washut?
Thank you, Mr. Chairman. And I'm just thinking back to my days when I worked internal affairs and sometimes, at least in my agency, we got a number of these complaints internally, or one officer files a complaint against another officer. And so there's no public outcry, there's no public awareness. The purpose of the internal affairs, and this predated this decertification. So I'm old, but before the decertification process came along, so there may be some changes today, but the purpose of the internal investigation dealt with, should we retain this person as an employee? And so if the person leaves, how would we even know that a complaint had been received and an investigation wasn't completed? I don't think anything wrong with the amendment. I'm going to vote aye on the amendment, but curious to see what the rest of the discussion leads to on the remainder of the bill.
And Representative Washut, the one thing we never discussed is whether your honeymoon story would fit within. But we won't have that discussion on the public record. All right, question on the amendment. All those in favor of the amendment signify by raising your hand. All those opposed, the amendment carries. You have another amendment, Representative Craigo, or amendments?
I do.
All right,
Mr. Chairman, I think we need to, Representative Provenza referenced this earlier, we need to make some conforming amendments.
Okay.
And change the lettering starting on page 2 at the top. M needs to be L, and then we need to fix the rest of the letters within the bill. There are several of them.
Representative Oakley?
Thank you, Mr. Chair. And I think maybe Representative Yin knows too. There's something where they don't use the letter L in statutes because it looks like I. So that's actually done on purpose.
Is that right, Representative Yin?
Mr. Chairman, I believe that's correct. I went and looked at our sales tax because I know we have a bunch of subsections in sales tax and they don't use the L, I think specifically because it looks like I.
Representative Zwanitzer? Is that right? That's right? Okay,
Withdrawn.
withdrawn. All right, we all learn. I never pay enough attention to those letters to ever be concerned in my 4 years, but now I hopefully I'll remember that. All right, Representative Provenza.
Thank you, Mr. Chairman. I don't think I'm gonna bring this amendment right. Well, I think we can talk about it, but the Mr. Director Walsh had mentioned that he'd like to add similar section or wording to 9-1-710, which would cover hiring of corrections officers. And this, my understanding is that this would fit in section B under 710. And that would be adding Romanet I or Romanet 9, 10, 11, and 12.
Okay, hold on. Hold the horse. Okay, so the bill title is limited to, are we okay here? Because the bill title is relating to peace officers, and we are, because a corrections officer is a peace officer by definition.
Yeah, Mr. Chairman, that's correct. Peace
Okay.
officers encompass quite a range of folks. and
So there's
corrections
a,
officers are
okay,
one.
so there's a separate, so there's a statute. So why aren't they already under 9-1-704 qualifications for employment as a peace officer?
I thank you, Mr. Chairman. I had that that question as well, which is why I'm bringing this to the committee and potentially bringing it after talking with LSO sometime between now and first or second reading. But his concern is that it just needs to be added in that section as well, so that correctional facilities would also understand that they need to report that serious misconduct information.
Oh, so it's just the reporting requirement.
I think he included, my understanding is it would like the full extent of it, but I don't think that is necessary because they are considered peace officers. But just the issue of reporting to post when serious misconduct occurs is what I think needs probably to be added to that section. But again, I'm not 100% sure on that. I'm just bringing this to the attention of the committee. If we think it fits, great. If not, I'll do more conversations with LSO to verify that makes sense.
I would say let's follow up with LSO
Okay.
because all of the reporting, everything is under the same statute, 9-1-704, and it's if peace officer includes a detention officer by definition, or corrections officer. Do we call them detention officers at all in the state of Wyoming?
In the jail.
In the jail. So we're talking about corrections or prisons. So we're not talking about detention officers,
I think they fall under.
or they probably fall under it too, including game wardens. So it's and brand inspectors. All right. So it seems to me that we should follow up with LSO. And I guess I'd have to go look at 710 as well. And because if we are going to do something, it might be easier to combine. I don't know what all is in 710, but I don't know why. Well, I don't even know why you'd need it if they're already within the definition of peace officer, but let's take a further look at that one, I think. Okay, other amendments, committee? Question being called. Clarissa, please call the roll.
Did we vote? The amendment?
Oh, wait,
Yeah, we did.
did we vote on the amendment? Yep, okay. All right, Clarissa, please call the roll on House Bill 247, law enforcement hiring practices.
Representative Crago,
Aye.
Representative Larson,
Representative Larson leaves an absentee voting form, and for House Bill 247, he votes no.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Vice Chair Washit,
Aye.
Representative Williams,
Excused.
Representative Yin,
Aye.
Representative Zwanitzer,
No.
Chairman Olson.
Aye.
Mr. Chairman, we have 6 ayes, 2 noes, 1 excused.
Perfect. That clears the desk. Judiciary Committee, good job. Clarissa, can we meet up so I can hand off these absentee voting forms to you for the standing committee report, please?
Absolutely. I will run down there as soon as I stop the YouTube stream.
Okay, great.